All right, people, welcome to Jumbo IS and welcome to lecture number 7 from Polity in this lecture series called Prelims Powerplay 2026. Through this lecture series, we get to revise our entire syllabus for Prelims 2026 examination. The entire syllabus. That includes current affairs, all current affairs segregated subject-wise, as well as the associated static topics. Because we all know that static topics which have some connection with current affairs have a higher chance of featuring in your prelims examination. Therefore, we would cover everything, current affairs as well as the static portion. Now, to cover this lecture series properly, you have to follow these 4 steps. Step number 1 is watch the lecture regularly. Every day at 9 p.m., the lecture would drop on YouTube. You just have to be regular with it. Be regular, don't keep your lectures pending until your prelims examination and everything would be revised. Then step number 2, along with this lecture, we will provide you with notes. These notes would contain all the information covered in the lectures plus some extra information as well. Step number 2 is memorize these notes just after watching the lecture. Then step number 3, we have enrolled you in our WhatsApp groups. These WhatsApp groups are specifically created so that you can ask your doubts anytime. You will have 24/7 access to us through WhatsApp. So use those WhatsApp groups judiciously. Ask your doubts as soon as they occur to you. And step number 4, well, along with this lecture series, you'll also be getting access to our prelim-specific test series, which will contain an exhaustive list of tests. Be regular with those tests. This test series is given to you complimentary with this lecture series. Make sure that you use it properly. Be regular with the tests. Don't keep your tests pending. Okay? Now, as far as step number 1 is concerned, you don't have to worry about that because the lectures would be dropping on YouTube. It is for everyone to see. But for notes, for WhatsApp groups and for the test series, you would have to register on our app or on our website. The links to both are given in the comment section just below this video. You just have to click on the link and fulfill some formalities and you would register for this. Okay, enough of the introduction. Let's straight away jump into today's lecture. And our today's topic of discussion is tribunals. And the reason why we are studying or we are talking about tribunals in this particular lecture is because, well, recently in the year 2025, well, Supreme Court basically struck down a law made by Parliament of India. That law was called Tribunal Reforms Act. Okay, so that act was enacted by Parliament to reform or to make certain changes in the way tribunals function in India. But Supreme Court found those changes unconstitutional. Basically, the argument of Supreme Court was that through this, you are basically harming the independence of judiciary, doctrine of separation of powers between executive and judiciary. You are trying to make the judicial branch of the state dependent on you. But we want judiciary to be independent. So that is why Supreme Court struck it down. Okay? Now, what was tribunals? What was this act, Tribunals Reforms Act? Okay, what is the system of tribunals in India? That is the static part. Okay, what are tribunals? How do they function in India? What are the constitutional provisions related to that? Then what is Tribunals Reforms Act? And what problems did Supreme Court of India have with this Tribunals Reform Act? And what did the Supreme Court judgment say? We'll cover everything. So pay close attention, give me your 100% and let's begin. So Polity lecture number 7, tribunals. Look, whenever there is a dispute, okay, for that we have courts, right? At the top is Supreme Court, then there are different high courts, and the bottommost branch is subordinate judiciary, right? This is the district courts and all. So this is the judicial system in our country. But sometimes some disputes require specialized adjudication. For example, income tax disputes should be handled by those judges, those courts which are specializing in this particular area, right? So sometimes we need specialized judiciary as well. For that, we have created specialized tribunals. So there is an income tax tribunal, okay? There is a Central Administrative Tribunal, which deals with services, IS officers, services related disputes. Then there is State Administrative Tribunal. All the administrative officers in the state, well, in case there is any dispute, well, those would be handled by this specialized judiciary. These specialized tribunals were created, number 1, to create specialization, and number 2, to lessen the burden on Supreme Court, High Court, and subordinate courts. We all know our judiciary is overburdened, and that is why there is pendency of cases. So to reduce all of that, well, the idea of tribunals was floated, and they are functioning very well in India. Okay, so what is the legal system through which these tribunals function? Let's talk about this. Okay, so the reason why we are studying tribunals, because recently Supreme Court struck down Tribunals Reforms Act 2021, which basically made changes with respect to appointments of members of tribunals, their tenure, their service conditions. Basically, the Supreme Court said that these changes would make these members of tribunals more dependent on central government. So they would be more dependent on central government, and they won't be able to give any ruling that is anti-central government. They won't be independent in that regard, right? Because they're too much dependent for their appointments to these tribunals on central government. Nonetheless, we'll talk about this, okay? Now, what are tribunals? So tribunals are judicial or quasi-judicial institutions established by law to provide a platform for faster adjudication, okay, faster disposal of cases compared to traditional courts, because traditional courts are overburdened. Plus, some of the judges, a judge who is not specialized in income tax but is hearing an income tax case, that happens in our high courts, supreme courts, or subordinate courts. That doesn't happen in tribunals. Now remember, these so-called judges in tribunals, because in tribunals the adjudicators are not called judges, they are just the members. They are called members, and well, they also have a chairperson. Like there is CJI in Supreme Court of India, similarly there is chairperson, and all the other judges are called members. That is why I'm using the term members. Nonetheless, so about the tribunal system in India. So tribunals were allowed as per the Constitution of India through 42nd Constitutional Amendment Act. So basically 42nd Constitutional Amendment Act, the mini Constitution of India 1976, inserted two articles, 323A and 323B, dealing with tribunals. Okay, so tribunals in India have a constitutional status, by the way. Okay, and which constitutional provisions give these tribunals that status? 323A and 323B. Now, Article 323A empowered Parliament to constitute administrative tribunals. For example, you're an IS officer, but you were wrongly transferred, wrongly dismissed, or there were many other wrongful things that happened to your service. You can raise a dispute, okay? And those disputes are resolved in administrative tribunals. Article 323 allows the Parliament to enact a law to establish these administrative tribunals. So remember, Article 323A deals with administrative tribunals only. And based on this 323A, Parliament has enacted a law through which Central Administrative Tribunal has been established, which deals with service disputes in central services. And different state administrative tribunals have been established, which deal with employees of state governments, okay, for adjudication of matters concerning recruitment, service conditions of public servants. Okay. Now, 323A only deals with administrative tribunals. What about other tribunals like income tax and many other things? Well, Article 323B has given the authority to the Parliament to establish all the other tribunals. All the other tribunals apart from administrative tribunals are formed under 323B by a law made by Parliament. Okay, simple. So Article 323B specified certain subjects like taxation, land reforms, for which Parliament or state legislatures may constitute tribunals by enacting a law. But just remember, tribunals will be established only via authority of a law, either by Parliament or by state legislature. Simple. 42nd Amendment Act inserted. Okay, so this provision we already know. All right, this is a repeat. Now, certain key facts about tribunals. Okay, these key facts are important because MCQs can be created from these provisions. So pay close attention. So currently, tribunals have been created both as substitutes to high courts. So whatever disputes used to go to high courts now go to these tribunals. So these are substitute to high courts. Whatever disputes used to go to judiciary subordinate to high courts like district courts and all, well, there are tribunals for that as well. So there are two types of tribunals. Tribunals which act as substitutes to high courts, tribunals which act as substitutes to subordinate judiciary. Okay. Now, if you are unhappy with the decision of a tribunal, you can appeal against that decision. Okay. Now, in case of those tribunals which were established which were established as substitutes to high courts. The appeal lies in Supreme Court. Okay, and in case of those tribunals which were established subordinate to high courts or substitute to subordinate judiciary, the appeal lies in High Court. Clear? But in 2017, in Chandan Kumar case, the Supreme Court held that in case of those tribunals also which were established as substitutes to high courts, the appeal will first lie with the division bench of High Court only. So the appeal won't go directly to Supreme Court, it will first go to the division bench of High Court. Now, what is a division bench? Well, more than one judge bench. So mostly it is a 3-judge bench. Generally, for subordinate judiciary, the appeal lies with a single judge bench of High Court. But for those tribunals which earlier could appeal to Supreme Court, well, they will first go to the division bench of High Court and then to Supreme Court, next appeal. Okay. In 2010, Supreme Court held that subject matters under Article 323B are not exclusive and could extend to any subject matters mentioned in 7th schedule. 7th schedule mentions the powers of center and state. So all those subjects or tribunals on all those subjects which are in central list can be made by parliamentary law. Tribunals on all those subjects which lie in state list can be made by state legislative assemblies law. Clear? But Supreme Court said you can create any type of tribunal. Clear? Not just only related to taxes. All right. Now, why are tribunals important? What is the significance? Very simple. First of all, we talked about specialization. Income tax tribunals would have income tax experts. They would be better equipped to give out judgments, right? Then it reduces pendency in our existing judiciary. If there were no tribunals, all these cases would go to high courts or Supreme Courts. High courts and Supreme Courts are already too burdened. So this reduces pendency. And because these tribunals are not that burdened, they dispose of cases very quickly. So speedy resolution of cases also. Plus they are specialized also. So that's why these cases are disposed of very quickly. And last, improved accessibility. If there is a dispute, if you have a case in Supreme Court and you live in Chennai, for every hearing you would have to travel all the way to Delhi. That can be very difficult for some people. But in case of tribunals, tribunals are established all over India. So justice is more accessible, closer to your home. So this is one thing. Okay. By the way, in your notes, I have also mentioned evolution of tribunals in India. Okay. So tribunals were first established. Okay. The first tribunal in India was in 1941 during British rule, the Income Tax Tribunal. After that, well, in 1969, First Administrative Reforms Commission said that we should have tribunals. Then Swaran Singh Committee, which advised for fundamental duties, also said we should have tribunals, and based on this committee's recommendations, 42nd Amendment Act was passed through which tribunals were created. You all know this. Then there were some other developments also which are given in your notes. Just go through this. Minor developments. All right. Okay. And now let's talk about the highlight of the day, basically the reason why we are discussing tribunals, and that is because of this controversial law called Tribunals Reforms Act. Okay. Now, what was the problem with this Tribunals Reforms Act? Okay. Central government in 2021, basically Parliament enacted a law. Through this law, the tenure of members of tribunals was shortened to 4 years. Plus more powers were given to central government with respect to appointment, tenure and conditions of service for these members. This makes these members way more dependent on central government. They would have to oblige central government, because if central government is angry with these members, they can transfer them, dismiss them. Basically, central government was given way more powers on these members. Now that harms independence of judiciary, which Supreme Court says is not right. So Supreme Court struck down this law. Now, what were the controversial provisions of this Tribunals Reforms Act? So tenure and age limit. First of all, the tenure was reduced to 4 years. Okay. Plus minimum age was kept at 50 years. So young lawyers or young dynamic people cannot become members. Okay. Then to appoint members, a search cum selection committee would be created. Okay, to give recommendations regarding chairperson and members to appointed by central government. So appointments would be made by central government, but recommendations as to who can you, I mean, this committee will give a list of names and central government would choose from this list of names. Now, the search cum selection committee, basically whatever recommendation is given by this committee would be followed by central government. Now, this search cum selection committee will have a chairperson who will be either CJI, Chief Justice of India, or a Supreme Court judge appointed by CJI. Then members of this committee would be two IS officers of the central government, two secretaries appointed by central government. And then, if you are making appointments to tribunal members, then opinion of the chairperson of that tribunal would be taken. Or if you are appointing chairperson only, then opinion of the outgoing chairperson, the previous chairperson, would be also taken in this committee. Okay, the details are given in your notes. Do read it out. Now, Supreme Court has struck down the provisions related to appointments, tenure and service conditions of members of various tribunals. Supreme Court has struck down this act, basically, and Supreme Court was not happy that central government or parliament enacted this law, basically centralizing tribunals, grabbing more powers from tribunals, reducing independence. So what was Supreme Court's judgment? Supreme Court held that members should have at least 5 years tenure. Okay, 4 years tenure is too short. And they would always be thinking about being close to central government so that they are reappointed. And that lawyers having a minimum 10 years of experience must be considered for appointments. There should be no 50-year age limit. Young lawyers, 40-year-old lawyers which have 10 years experience in the legal field can also be appointed. Okay. Composition of search cum selection committee. 2020 rules failed to ensure judicial dominance in the committee. Basically, the composition of the search cum selection committee was based on the rules notified by government in 2020, which were struck down in the Madras Bar Association case. But Parliament then enacted a law. So you understand, these provisions with respect to the search cum selection committee were first notified as rules. Those rules were struck down by the courts. Then the government thought a way out. They enacted a law. Now the Supreme Court has struck down that law as well. Okay, so that was going on. Supreme Court has also said that within 4 months establish National Tribunal Commission, an independent body to supervise the appointments, functioning, administrative and infrastructural need. Okay, SC held that until the Parliament enacts a new law, this law has been struck down. Until Parliament enacts a new law, the advisories, the directions given by Supreme Court in Madras Bar Association case 4 and 5 will continue to operate. Okay, so this was the thing. Just remember the controversial provisions and just remember that Supreme Court's opinion on these controversial provisions. Okay, Supreme Court was not happy with this because the government was trying to bypass Madras Bar Association directions. Supreme Court is not happy with this because Supreme Court thinks that this 50-year age limit is arbitrary threshold and this 4-year tenure is not enough. Minimum 5 years is required. Clear? That would be all. With that, we conclude today's session. So thank you so much for watching, everyone, and I'm sure it has added value to your preparation. But it would add more value, number one, if you're consistent and regular with this lecture series, and number two, you follow those 4 steps which were discussed in the beginning of this lecture. Follow those 4 steps. And I shall take your leave with the promise of seeing you again with another topic in this lecture series called Prelims Powerplay. Thank you, everyone.